I guess I would like to hear, and I certainly will make my statement as to why I made the decision to support Mr. Carpenter's RFQ, but there were two other people that were involved in this process, and I would like to hear from them so that the council can hear what went into this process. I think to issue a liquor license is a very serious decision-making process, and that it impacts the community in many, many ways. And I personally feel that we need to, there's a lot of responsibility that goes into managing and owning a liquor establishment, as we know from past history and the differences between establishments that I think are credible and those that we've had difficulty with. And I will share without a doubt why I am opposed to the first speaker and having to go back there to Unified Productions. But I would also like to hear from our police chief and from our city attorney who was part of the process, and then I will give my statements and then we can hear from the council. Ms. Gass?
My concern as the arm of the city that acted in prosecuting the violations for the former licensee were that the sole stockholder of Unified Productions was the mover and shaker behind those violations. We had DKB1, which operated that location as the U at 1000 West Lincoln Highway. Mr. Tomkowitz renewed that license based upon an installment agreement with Mr. Oxner. I believe it's University Investment Properties. And that was done basically 2 days before his 2008 liquor license expired. At that time, he advised us that he was trying to bring a member into his LLC, Aranzi Vasquez, and Mr. Vasquez was told that he had to undergo a background check and fingerprint investigation. During the course of that investigation, he disclosed to the police investigator that there was a business agreement between himself, Mr. Tomkowitz, and Mr. Oxner, the owner of University Investment Properties, in which Mr. Oxner basically paid $40,000 to buy out Mr. Tomkowitz's interest. This was without any approval of the city, and at the time that the license was renewed, without any knowledge on the part of the city. In September 18th, there advertised a party in which the new name of the facility was called Detox, and Mr. Vasquez was holding himself out in the press as the owner of the facility. That party encompassed the sale of wristbands. For $10, one could purchase a wristband, get into the premises without having an ID checked, and for 5 hours could drink all of the beer and alcohol, as long as it wasn't a call brand, that one wanted, which is a clear violation of the happy hour laws, our happy hour laws and the state happy hour laws. Two of our undercover police officers went into the facility and purchased alcohol and were there. During that time, they questioned bartender, they questioned the bouncer as far as what the wristbands entailed, and they were told you can drink as much as you want for 5 hours. When the police arrived and issued citations, Mr. Vasquez was questioned. He held himself out to be the owner of the property and said that he wasn't aware of what was going on. My concern is that if all of the bartenders that were questioned by the police and the bouncers and everyone else knew about this party, and Mr. Vasquez was in fact acting as either the owner or the manager and didn't know about it, he should have. Citations were issued, and that was the basis of one of the violations of a liquor hearing that was held in October 12th. But in between that September 18th date and October 12th, there was a state of Illinois liquor control sting. This was utilizing personnel, including our police officers and some of our young underage confidential informants that go out and basically try to purchase alcohol. And there were, I believe, 5 licensees that were found in violation, and one of those was the U or detox, whichever name they want to call it, in which two of the under 21 individuals were allowed entrance without having their IDs checked and were served beer at the bar without having been carded. Again, Mr. Vasquez was the person in charge of the bar at that point in time. So that was the second basis of the liquor charge. And when we had our hearing on October 12th, Mr. Tomkowitz appeared, Mr. Vasquez appeared, and I recall that Mr. Oxner was there also. And Mr. Tomkowitz, on behalf of the licensee, DKB1, basically admitted to those two violations, the happy hour violation and the underage service of alcohol. A fine was imposed, and there was an extensive discussion as to who was actually operating the licensee. Based upon my recommendation, and I believe with Mr. Onken's approval, we continued the hearing to give DKB1, Mr. Tomkowitz, and Mr. Vasquez time to provide information as to who was actually operating that licensee. That was on the 12th, or excuse me, that was on October 30th. The next hearing was on November 12th. During that time, because of our concern as to who was operating it, the liquor commissioner ordered the facility closed, and it has in fact been closed since October 30th. Nothing was ever submitted by Mr. Tomkowitz or Mr. Vasquez as far as who was operating the facility. Rather, they came in on November 12th and represented to the liquor commissioner at the hearing. And I'll remind you that these hearings were both on the record. We're probably going to have to get transcripts of those prepared, but whatever they said is on that record. And they said that the agreement that they had signed on August 29th, which referenced this $40,000 payment and transfer of the ownership interest from Mr. Tomkowitz to Mr. Vasquez, was never really fulfilled, so we should ignore it, and it's void, and they had a new agreement to show us. Based upon the information that was set before the liquor commissioner, I believe the record would show that he indicated that he felt that it was appropriate to revoke the license because of the two violations and because it appeared as though there was a subterfuge going on in who was operating this contrary to the application and contrary to what was stated to the city. Mr. Tomkowitz asked the liquor commissioner if he would be willing to hold that revocation in abeyance if the license was surrendered. The liquor commissioner said that he would in the event that the outstanding fines and costs were paid by a date certain, and they were in fact paid by that date, and the license in fact was surrendered. My concern is that the same individual who was operating this facility from September 1st until October 30th, and at the time of those two violations, and was part and parcel of perpetrating a fraud on the city, is the sole stockholder of Unified Productions. And that particular pattern of conduct with two violations in the course of a 2-week period, when we see numerous licensees who don't have two violations in 5 years or 10 years, in my mind does not bode well for the viable operation of a law-abiding and outstanding liquor facility that we need in the city. That was the basis of my recommendation for denial of the license application that Unified Productions filed, and that is the basis of my recommendation to the liquor commissioner and to all of you that this is not the appropriate person that we want for a licensee in the city.
Thank you.